All right. Court of Appeal in the 46th District of the State of Florida is now in session. Honorable Dan Traver, Chief Judge, presiding. All persons having business before the court, draw near, give it and will be heard. God save the United States of America, the state of Florida, and this honorable court. Please be seated.
Thank you, Marshall. Good morning, everybody. Welcome to an oral argument session of the 6th District Court of Appeals. My name is Dan Traver. I'll be the presiding judge today. I want to introduce you to the rest of the panel because I understand that there was some suspense as it related to that. This is Judge Mary Nardella. She's on my left, and this is Judge John Stargell. He's on my right. This is being live streamed on YouTube. So for that reason, please be mindful that your comments will be recorded for posterity. And also, if anybody who hasn't silenced their cell phones already could do so, we'd be excited about that. There's one case on today's docket. It's Lakeland Regional Medical Center, which is doing business as Lakeland Regional Medical Center, versus Laura Van Kampen. It's case 23-300. And counsel. Mr. Sen, 5 minutes for rebuttal, or would you like more or less?
5 minutes would be fine.
Terrific. Whenever you're ready, sir.
Thank you. Good morning, and may it please the court. I'm Steve Sen, the attorney for Lakeland Regional Medical Center, a hospital in Lakeland, Florida. And I'd like to begin with a quick overview of the governing law that our issue 1 is based upon. In Gooding versus University Hospital Building, the Supreme Court made clear that a plaintiff in a medical malpractice case has the burden of proving that the injury was caused by the breach of the standard of care. Possibility of injury is not good enough. It's got to be 50% or more, and the proof has to be to a reasonable degree of medical certainty.
It's an interesting spectrum case. I think you'd have to agree with me in terms of the time frame. You know, if we were talking about 20 seconds, obviously your client would have a much stronger case. And I think you'd have to concede that if we were talking about 2 days, your client would have a much weaker case, correct?
That's correct, Your Honor. And the cases that we have cited and reviewed involve a range of time periods. Gooding, it was 45 minutes. The person showed up at the hospital and the testimony was that if they had promptly done the necessary diagnosis, that was treatable and survivable. But the court said that the best view of that evidence in the plaintiff's favor was survivability of 50%. 50% is not good enough if the burden is to prove by a preponderance of the evidence that it was more likely than not.
Just really struggle with how this decision isn't a jury issue when you start talking about the time frame that you had, and then the testimony from the doctor that the more time that nerve is compressed, the greater damage there is, greater chance that there is a permanent injury. You know, it just from the perspective of where I'm having some difficulty with it, to be candid, is you're talking about taking something away from the jury that kind of seems like a quintessential causation issue. Beyond Gooding, is there any way that you could assuage my concern?
Well, the cases that we have cited apply Gooding and do apply. We would submit a fairly searching inquiry to whether the evidence is adequate. Here, there's not just one question mark, there's 2 question marks. And you can't do math if you don't have either of the numbers that you're trying to count from. We know it was a relatively short time period. We know that she fell and she was in a painful position. She called out for help. Her voice was, her throat was dry. She didn't think she could be heard because the door was closed. So she then pressed her button. And then between 7 and 8 minutes, the nurse showed up. It is a fair inference from her direct examination where Dr. Shepard, she is a professor of nursing, not a medical doctor. Dr. Shepard said that she could not give any evidence as testimony as to causation. She would rely on the doctor. But in her direct examination, she did say that 7 minutes, in her opinion, was too long. We then.
I think it's also got to depend right on the injury. I mean, there's a reason why for certain types of incidents, everybody comes running and sirens start blaring in the hallways, right? When somebody goes into cardiac arrest, mean, there's a recognition there as a matter of fact that time is very much of the essence. And again, it kind of harkens back to my concern, which is that if 2 days is not great, 30 seconds is probably fine. How do we not have a jury decide that 7 minutes is or isn't okay based on Dr. Shepard and Dr. Fisher's combined testimony?
Well, the review we're asking this court to do is the same review as applied in these other cases. Is this evidence that a jury reasonably could rely upon to find that it more likely than not, to a reasonable degree of medical certainty, the injury was caused by a breach of the standard of care? And when the standard of care itself is not clearly defined, and when the causation evidence is not clear as to when the injury occurred, you have two uncertainties that bear directly upon whether that 50% more likely than not standard has been met. That's the plaintiff's burden of proof. And absent evidence that more likely than not, here's what happened. She fell, she called out, that didn't work. So then she pushed the button. And at some point during that 7.5 minutes, arguably, based on testimony, the standard of care was breached. We don't know whether that was sooner than 7.5 minutes. And then at some point during that 7.5 minutes, her injury went from being not a permanent injury to a permanent injury. But we don't know what point in time that is. And with both of those items being uncertain, it's simply unclear, and you can't determine more likely than not to a reasonable degree of medical certainty that the injury or that the breach of the standard of care caused the injury. That's the plaintiff's burden.
What hypothetically would that testimony then look like for you? What should Dr. Shepard have been a different type of witness?
No, certainly if Dr. Shepard had said, and she tried to fix this on redirect, or the plaintiffs tried to fix this on redirect, that response to a nurse call button under the standard of care in this community is X, and then whatever caveats that may be necessary. And then Dr. Fisher, the causation expert, had said, well, Dr. Shepard said that the standard of care was to respond by X. If they had responded by that time, she still would have been injured, or she would not have been injured. They could have fixed it. That would have tied it all together. But we have these two things that are not tied together.
One more time. I don't think I followed that.
I'm sorry.
Could you say that to me one more time? I don't think I followed that.
If
My fault.
Yeah, no, my throat's dry and I'm probably stuttering a little bit, but if Dr. Shepard had said the standard of care in the community for responding to a call button is X
4 minutes and 12 seconds.
If she'd have said that, sure. And then she could have said whatever caveats, unless the patient's coding or all the other things that nurses have to deal with. And the causation expert had said that I understand the standard of care is X minutes based on
4 minutes
Dr.
and
Shepard.
12 seconds. It's more than 4 minutes and 12.
He would have been permanently injured
Yeah.
at Y. And so therefore, if they'd have responded in 4.5 minutes or 4 minutes and 12
Or
seconds,
4 minutes and 12 and a half.
then she would
seconds.
not have had a permanent injury.
Right.
But we just don't know.
Is there a way to know based on what Dr. Fisher was saying? Yeah, take your time. Is there a way of knowing based on what Dr. Fisher was saying? It didn't seem like there was anything that was brought out in the direct across. Maybe this is more of an academic question. That would suggest when a nerve becomes permanently damaged.
The
So in
evidence
other
on
words,
that,
could a nerve become permanently damaged both before and after your hypothetical 4 minutes and 12 seconds? My hypothetical 4 minutes and 12 seconds.
I think the answer to that is the record does not provide that information. And
that's probably because there's not a real scientific answer to that. There's no one moment in time that scientists can point to and say, this is, if it's 4 minutes and 15 seconds, then you're toast, because that's going to differ between patients, correct?
that's right. But if there's not evidence to a reasonable degree of medical certainty that the injury had occurred by a time period that would not have occurred if the standard of care had been satisfied, then the plaintiff loses their case. That uncertainty, to the extent it exists, is not a problem for the defense. It's a problem for the plaintiff
So
to
you agree
overcome.
that the standard of care also could vary based on things like how recently did you get out of surgery? You're still groggy from, having a surgery. You're sitting in a chair and maybe you should come back within a period of time, whether a light was on or not, to check to see how this patient's doing.
Yeah, that's absolutely true. And we have cited different cases dealing with similar that talk about a quicker standard of care may be necessary. For example, a bed alarm. The appellee in their answer brief cited a number of bed alarm cases. In those cases, we know we have a patient who is a fall risk. For that reason, they are given special equipment to alert nursing staff if they're trying to get out of their bed, so that they can promptly, and the way the thing works, it lets you know somebody's trying to get out of the bed. You need to get there before they get out of the bed, because that is the risk of harm to them. Dr. Shepard testified that and there was no other testimony to the contrary, that this was not a patient that required constant monitoring or that sort of individualized
Well, let me ask you about that.
treatment.
There was a nurse that knew that she'd got up and tried to walk and gotten nauseous.
Correct. That was her rehabilitation therapist. Yes, sir.
Okay, sorry.
And-
So they were aware, the staff was aware that she was not able to currently move around, and even if there wasn't a button that went on, nobody came back to check on her to see how she was doing after she had been nauseous for some period of time.
Well, 7 minutes is
Well,
what.
7 minutes is from when she actually hit the button.
But
I
there's
mean,
also
we
evidence
don't know
that,
how long she was actually sitting there before, so there's a period of time in excess of 7 minutes that nobody came back to check on.
that's
how she was doing.
actually the record is that there was a nurse who came in just a couple of minutes before
Right.
the call button went off. So she was not sitting there for a prolonged time period.
No, but it was longer than 7 minutes. You said
Yes,
7 minutes,
her-
so it was longer than 7 minutes since any of the staff had been in to check on.
After her husband left, a nurse came in to check on her according to the electronic trails that everyone had been relying on. And that it was a couple of minutes after that that she pressed the call button. So the time that she was alone was, put it all together, maybe 10 minutes at tops. So it's not like this is somebody languishing, and there are horrible cases like this, languishing in a bed and can't get help, and hours pass and bad things happen in those hours. This is a fairly short time period. And what is unique about this case is when you determine that the standard of care, as apparently the jury did here, and this court is asked to affirm that, is effectively immediate response to a call signal, that puts all hospitals on notice that they have a duty to respond immediately to a nurse call button. There is no case that has supported that. That is not consistent with the actual standard of care.
See, that's an interesting that's an interesting kind of flip side to the argument that you were making to me earlier, because let's say that it wasn't an immediate response. Let's say that it wasn't the code blue sort of situation, because obviously hospitals have the resources to respond immediately to some type of stimuli to the human body.
Certainly.
I think what would happen is that hospital care would get really, really, really expensive. But we know, for example, that it works because people can show up. I think that your client would have had a much easier case in front of the jury if that response had been in 2 minutes and 30 seconds, as opposed to 7 minutes, which brings me back to the question of like, how isn't this a jury question? At what point does the time become a matter of law? 10 seconds? And I understand what you're saying in the context that if we write a reversal opinion, we don't have to touch that, it would appear. It would appear that we just say that it's a legal failure to elucidate the standard, that the legal standard in the case in chief. But as a matter of how people might read the decision with those facts, that's another thing that I'm struggling with.
Well, yes, our argument is not that this court should decide as a matter of law what the time period is for response. What we're asking the court to decide is whether there was sufficient evidence as to what the standard of care was for a response time. And that's where the problem is. Perhaps if you are reading the plaintiff's case on her direct examination when she's describing her opinions, Dr. Shepard did indicate that 7 minutes in her opinion was too long. Later on, she tried to say immediately or as soon as the light went on. And that is the standard that the jury apparently relied upon, because we do not otherwise
How do you know that?
Well, the likelihood of, otherwise you have like a split second time, and perhaps I don't know that, but otherwise you have a difficult.
Which is part of the challenge with this being, again, seemingly something, causation is usually a jury question. If she says, and it seems like we've honed in entirely on Dr. Shepherd's testimony,
Mhm.
which is basically that 7 minutes is too long. That seems to be the argument, is that that's not good enough. Are we there?
Well, the
Or-
argument is that there wasn't then causation testimony that the injury would not have taken place anyway in a shorter time period, and whether a shorter standard of care would, by which even if the nurses had complied with the standard of care, the injury was already permanent. That's the possibility that is not excluded to make their 50% or more likely burden of proof satisfied. If the nurses had shown up after 5 minutes, if that was compliant with the standard of care, but she was already already had permanent injury to her nerve, then the injury was not caused by a breach of the standard of care. And we have these missing numbers that don't allow, that don't satisfy the plaintiff's burden of proving that the injury was caused by the breach of the standard of care.
Can I switch gears on you?
I'm sorry?
Can I switch gears on you? Talk about damages a little bit?
If you want to, surely.
Yeah, so the
I
concern,
only have about 5 minutes left, but
oh, yeah, you
but-
want to just,
I want to answer your question.
no, that's okay. Let's do that on rebuttal because I'll ask your colleague about it.
Okay, thank you.
Thank you so much.
Good morning.
Morning.
May it please the court, my name is Celine Humphreys and I represent the appellee, Mrs. Van Kampen. It sounded like you wanted to start off maybe with the
Yeah.
damages.
If you want to talk about the causation aspect of it first, we'll circle back to damages at some point.
Okay, I think what I'll do, given your questions, is only make just a couple more points. Just a couple fine points that we had made in our brief to make sure that those are understood as well. At core, what defendant's argument is a straw man argument. Defendants are arguing that it was our burden to establish that this injury didn't happen in 3 to 6 minutes after the call light went out, or that we didn't. Those arguments have no evidence. There is nothing in the record at all by them before this defense not at 3 to 6 minutes for the actual student. So by having a chase after that standard, that's not good a basis for drawing. And there was a nuance I wanted to make sure that the court heard. Even if we go with what they're saying now in the field, that response of 3 minutes after the call light or 6 minutes after the call light, their own defense expert, their neurologist that they presented said it would have been much more time for this injury to occur. Now, where he disagreed with us, and we say 7 minutes is not, he said it has to be more than 10. That's what it's really. So actually, he disagrees even more with them because he says to be sitting this long in this great position on the floor, the cause of permanent nerve injury would have taken more time. So that's my kind of big future response. I also wanted to highlight the report. I'm concerned about Dr. Shepherd's testimony. All of that is weighed for purposes of argument. I'll actually say 3 ways, but clearly 2 ways in the trial record. First, what they're arguing about Dr. Shepherd is they're challenging her testimony regarding negligence, the first problem in relation to the college. There isn't really an evidentiary argument saying that for various reasons, her testimony about the violation of the standard of care should not be considered. All of those are evidentiary arguments. They never raise those arguments. They can file a motion, they can object during her testimony, they didn't seem to one-eye her, nothing. So when they're complaining now on appeal, what they're asking you is not to consider her testimony. That is right, because they should have argued that below. But an even easier ground.
I understood the argument to be a little bit different than that, which is that whatever her testimony is unobjected to, take it as it is, the standard of care isn't met. That doesn't seem to me to be something that you would have to object to via Daubert. Because there's no requirement that you file a Daubert motion to challenge somebody. You can just always argue that to the court at JOA, or you can argue it to the jury in closing.
I agree. I think that, I mean, the way I read their argument is, it just wasn't enough. It didn't tip the scales. Yeah. So what are the other two? You said there were three reasons.
The stronger ground is that they should have said such a trial judge. When they moved for directed verdict during the trial, they should make this argument they did not. So they do not be argued once the jury verdict is found on new basis that they never asked the trial judge. And that's black letter law. Now, they did argue this post trial, but that black letter law applies it just. Can I go ahead and tell you why on the first point? And that is their arguments are.
It's your 20 minutes.
Yes.
But then I'll also say when we argue this and our answer brief, their reply brief does not respond to the fact that our position is all of their attacks. Going to the expenses, instead of me launching in, do you want to start?
Yeah, so my question for Mr. Sen, which he can handle, is welcome to handle on rebuttal. I'll just address it to you, although probably as a friendlier question. I'm wondering how, when we try to categorize down to the dollar amount, these different expenses that we're saying weren't supported by the evidence, how we would then instruct the trial court to adjust a $570,000 verdict that doesn't fit neatly into any of those categories. You know, when I look at the verdict form, it doesn't look like it was broken out in any way. So I'm wondering mechanically, when we talk about remitter, usually that's lowering something from something. How do we know that the jury didn't already discount some of these items or all of these items?
You're right, that was our shoulders practice. That's a Latin decision. You're dealing with economic damages. You're trying to show that the award that the jury returned is excessive. You need to be able to specifically identify something in the record that makes that clear, and then also has a map available line item. It's just not common. And that's a big part of our argument. When we go to the range of what we ask within the numbers, the highest range is almost 2 million. And the jury returned a fraction. Remember, I think this came through the rates. When the expert was testifying about the different things, some of them had ranges, maybe it's this or maybe it's that. So when we added up all those ranges, our low number is now 1.13 million, and our high number is almost 1.9. Jury returned 107,000. So that's half of the low number, roughly a third of the high number. How do we know? That's our primary argument. We don't have. We're ready to climb in and justify every one of the challenges that they make, but fundamental reason why is not to address this. I will go ahead and maybe touch on a couple of the ones that they wrote. I don't know, did you see the supplemental authority that they filed? They filed a supplemental authority in a case dealing with something somewhat similar, which is the main thing that they do. They challenge 6 different expenses. 4 of those expenses they challenge based on only arguing something else. They didn't do very well. So our response to the brief was, when you're saying, for example, the spinal cord stimulator, you're only citing one snippet of the evidence, which is when it was put in, it was dreadfully painful. The cord laid on the nerve and it was awful. So they argued to the jury, and they now argue to you, she's not going to get this. She's not going to have a spinal cord stimulator, so that should not be included. Our response was, let's take out the rest of it. Was evidence from 2 different treating doctors who said yes, it was going to happen, and they testified as did Hampton that problem during the test run was fixed, and the rest of it was a success. The only reason she had not yet. So, but on some of the categories, the evidence that they ignored came from one of our experts, Dr. Dr. Shansarian served 2 roles in this case. One, he was a life care trainer, right? Where he, for the jury, sums up your future care and explains it to them, in addition to the jury being in the expert doctor explaining it. But the second thing that Dr. Chancery did is also testify, relying on his main qualification, which is that of psychology. So he is somebody who has 3 degrees in psychology. He's a licensed psychologist. He's licensed in mental health. He's also practicing what's called rehabilitative psychology. So let me put those 2 comments together. It might sound like I'm bad. He was the conflicting evidence on some of that future care, including the new house or the new vital unit. So the testimony that we cite in response is Shansarian, what they say is, well, a neurologist didn't recommend. That was their whole argument. Counseling is not going to happen because they're treating well. He said, well, her opinion, Dr. Shansarian does. Also, she's on antidepressants. She's talking with her provider and they're not good enough. There's all this testimony not really. Their supplemental authority seems akin because it is a case where a life care planner provided testimony that related to care. And so what I thought I would do, since maybe you haven't seen that, is go ahead. I can't respond with writing. Is kind of take a moment to carefully respond and distinguish. In that case, first and foremost, the main argument by defendant against Dr. Shansarian was he was not allowed to give this testimony because it's manifesting. Well, counseling is not manifesting. It is psychological. They never responded to that. The second thing, when you look at the case, it's called Anderson v. It just filed maybe it's filed this week. In that case, the party, the plaintiff, did not disclose this other testimony. They planned to ask the life care planner. And in that case, the life care planner gave medical. Here, we fully disclose Dr. Shansarian's testimony. The third distinction is, in that case, not only did the defendant object, the trial court agreed and excluded the testimony. Here, the defendant never once challenged this testimony at all. So I am going to take a moment, if you don't mind, and just tell you about this and just give you the record sites. First, on the pretrial disclosures, initially, he was disclosed as vocational rehabilitation they were given his vocational rehabilitation evaluation report, which included findings on his mental health and psychological testing. That's in record 259, 269, 270, 272. Next up in the litigation, the plaintiff's witness also identifies him and the scope of his testimony. And the plaintiff's witness list starts on pages 616, the key pages of 621 and 622. He identifies his areas of expertise. He says his scope of employment in this case is to interview, test, and evaluate what can happen and provide its expert opinion as to the vocational rehabilitation plan. And then the other thing is not taking too long on this. I do want to tell you where in the trial transcript he also made clear he could give this expert testimony and support it. That's on pages in the trial transcript 1404 to 1405. And you can look at PDF pages of that 3047 to 3048. I'm almost done. He testified more about his qualifications in psychology and mental health in the trial transcript on pages 1406 to 07. And for that, it's PDF pages 3049 to 50. He also talked about his actual evaluation of Mrs. Van Campen on pages 1411, which is also in his P3057. And the next page as well. The defendant never objected for trial, didn't file a motion, didn't object during it. And if you look at Dr. Shansarian's testimony, you'll see that the defense made only 2 objections. So going to each of the points that they argue, they make a number of mistakes. First, on the walk with them, they misargue. They argue that conflicting evidence, they jury arguments, citing the evidence that supports them. Reading takes time to very carefully identify the rescue. They argued an inference, which is good for the jury, but not appropriate for appeal for my cost of evidence. And on the final cost, which is the need for a personal attendant and household care. Their only argument for that is why does she get that? Her husband did it. And so we had a couple of responses. First of all, can't take advantage of the fact that her husband retired early and doing this to avoid the situation that we himself called. There's no question in the law that this is an income expense, so there's no basis for being expense. And I guess it's a regional board or maybe the state. What we ended up having to do was find law. We represented the that we have. Secondly, they cite the rebuttal source statute. I expect you all know that fairly well. That's a common argument, right? This is not a collateral source. Collateral sources are not providing. And also, just as clear, the collateral source statute only applies to tax. And then the last point that I made on this was, you know what, even if you're right, if you just look at the last 4 years of her testimony, the last 4 years, her husband will be the testimony was uncontradicted that her need for all of this help is even greater. And chances are her husband will be much less, if at all. If you just take the last 4 years, the evidence establishes that that would be $245,000.
Counsel, can we circle back to your first argument where we discussed the fact that the amount requested and the amount in the life care plan, the amount worried by the jury, you know, how do we parse it out? But if I look at and I want to get your response to this, the life care plan, it seems like a large share of the life care plan is built upon the housekeeper attendant care services. So if we were to accept the argument that the appellant has made about the life care plan, how does that affect your first argument on the practical ground?
That's actually a perfect number about to explain. So if we accept their argument, the evidence is undisputed that the argument runs out of it. At the end, the last 4 years of her projected life, he's not going to be able to do this for free. So if you buy into this argument, you're going to have at least a small amount of her life where without question she's going to need this help. And so I was about to do that math. Those 4 years, the end of her life comes to $245,000. They have said repeatedly, aside from everything that was testing, that the recoverable amount is only $3,000. And then if you add in the spinal cord stimulator, just on that, that's $260,000, and that gives you the 16% during working. I might close on that unless the court has any particular other concerns that you'd like to ask me to.
Thank you.
I really appreciate the opportunity.
Yes, ma'am. Well, somehow I gave you 20 minutes again, which totally isn't going to happen. But we'll say, I think we say 5 minutes and 46 seconds was what I recall. So we'll just round it up to 6 minutes and go from there.
Thank you. If I can respond to a couple of things quickly on issue one, before I take to issue two, the waiver argument. Responding to the various waiver arguments that made, the arguments we were making here, we are directly or taking directly from the argument that the trial for case. In particular, the arguments regarding causation are the one argument. In the trial transcript case 2008, 2015, is where they are here. And defense counsel specifically argued that in regard to Dr. Shepard, and she said today, and I asked her, well, she never said when you call out the answer. So there's no evidence from this court standard here on the time of the call out other than the and goes on to say that there was no evidence follow them point by point. Although in this case, we're citing primarily the same two cases, relying primarily on the same two cases problem. So making the same argument, relying on the same quality, the waiver argument, well, we're going to create an evidentiary objection in order to argue the evidence. But also the argument we think we're not raised.
That's an interesting point because the rehearing rule actually talks about non-jury trials in that setting. I think the point that I might have been trying to make was that it's a little bit different in the sense that you could make the argument on JOA and you wouldn't have to raise it pre-trial.
Well, in the Aldridge case, the expert had testified and there was no objection to that. That it was survival injury had inappropriate treatment in provided. There was no objection to that testimony, yet it was also clear in the record that that was not addressed because we were basing that on the standard of likelihood of survival, because we based that on patients at major learning institutions. And so the level of fear at one institution is different. That gets to the question of the fallout as well. If she were in ICU or a cardiac unit or something like that, there may be a difference. This has been an orthopedic recovery. Because people who have hip replacements, knee replacements, those kinds of surgeries, and are recovering with an idea that they're going to be checking out the hospital fairly quickly. And something horrible happened during the operation is not even here.
Didn't I read something in the record that it was 2 to 3 days was the expectation that she would be before she was released?
I think she was going to be on her feet. I'm not sure.
Well, on the feet, they'd already had her try to walk,
Back to normal activity.
but I thought the record said that she was going to be there for a couple days.
Okay.
And she had just gotten out of the surgery.
I haven't heard of it. But yeah, that's. The point is, she was not in some kind of high risk scenario where any kind of call for help should have been treated in different things to here. Kind of consequence that we did exactly the action. But I hope I know it didn't be the patient period that was here, but that's part of why the standard of care, some kind of immediacy, they were relying on the events of the room below, is one of the absorption. Moving on to the
I asked you a question while you couldn't respond to it.
yes, how do we make the math? What the defense counsel did, and what we're asking this board to do is to consider whether the various categories future economic expenses and all about were supported by adequate evidence. Like their planner primarily relied on what the division was recommending the various items, and what the defense counsel argued was that a number of those categories were appropriate by counsel who were in the argument. If you add up the damage, future damage, in the life that we are not challenging. Those are the ones that are not challenging. You get 100. And so that's how we believe we have the other statute inquiry as to whether that's how we did it. The first PCA case that came out this early this year was not at all. The court said the question presented is whether an expert witness offered a life care plan may use this for her own medical opinion to calculate certain costs of medical care.
And you are out of time.
Thank you.
Thank you very much. Appreciate the presentation from both of you, both in the briefs and today. If we had briefs and presentations like this all the time, we would be very fortunate. So thank you very much for your work. We'll be in recess.